Hi, I'm Ian Hull.
And I'm Rebecca Rauws.
And welcome to Hull and Estates. We're listening to episode number 526. Hi, Rebecca.
Hi, Ian.
So today we wanted to talk a little bit about a recent Court of Appeal decision called Vanier versus Vanier. And it's 2017 ONCA 561, just came out in June of 2017. It's an important case, I think, on a bunch of levels. It's been highly commented on already, and here we are only in early July or mid-July now. Gosh, the month's gone by quick. And there's been numerous blogs and numerous writing already about the case for a variety of reasons. So today I want to talk about a few of those reasons. It's an undue influence case, and Rebecca, in a moment maybe we can just have you talk a little bit about the facts. Mm-hmm. But on for the appellant were Lionel Tupman of the Whaley Estate Litigation Firm and John Poyser, who is counsel at that firm and also practices across Canada in the area of estates, both superb counsel. And then for the respondent was David Delagrand. David and I have known each other for many years, and he's a senior estates lawyer and estate litigation lawyer practicing in Toronto out of Beard Winter. So there was a good cast of characters to argue an important case. The Court of Appeal came down with a decision through Justice Bonado, Trotter, and Epstein. So I want to highlight a couple of what I think are interesting points, and as I say, it was a hard-fought case, and at the end of the day, the Court of Appeal held in favor of the respondent, so upheld the decision. Why don't you just spend a moment here, Rebecca, talking a little bit about the facts?
Sure. So this was a power of attorney dispute. It involved Rita and her two sons, Raymond and Pierre. There had been a prior power of attorney naming a third child, a daughter, but that's not involved really in this litigation, so I won't really mention it. But there was originally a 2013 power of attorney naming both of the brothers jointly and severally. There had been some issue with Rita accessing some of her money in order to pay her basic expenses such as rent at her retirement home, and her one son, Pierre, came to her and said that Raymond was putting up a barrier to accessing some of your funds, and so the solution is to make another power of attorney naming me as your sole power of attorney. After that, Raymond then brought litigation challenging that power of attorney and seeking to have Pierre removed as Rita's attorney.
So it's a classic fight over powers of attorney and who thinks that they can be best suited for looking after an elderly parent. There's a couple of things that come out of it. One of them was this question of, and the cases are very clear in this regard, is that what is undue influence and how does it apply? But how does it apply in the unique situation of a power of attorney?
Right.
And doesn't undue influence even matter in power of attorney? Of course it matters in wills. It's a core element of any will challenge, is to whether or not you are coercing or you're improperly to the point of coercion influencing someone. There's always undue influence, and certainly between husband and wife when they're doing wills, there may be what would call influence, and that's okay. The courts have said with the wills context that's okay, but the Court of Appeal struggled a little bit and helped clarify a little bit on what undue influence means in the context of powers of attorney. The test is clear. In a situation where you receive a gift while you are alive, you, the recipient of the gift, have the legal obligation to prove that there was no undue influence. And that law has been around for 600 years, and the court didn't really play with that or cause any concern with that. It more or less flips a little bit when you get into a situation when someone's passed away, and the undue influence test is slightly different, and it actually, the recipient isn't quite as burdened legally, right. I guess we put it. So, without getting too, and we're not going to try to cover the whole case today by any means, it's a lengthy case with some really interesting points, without getting too deep into that. Those are the sort of the two struggles, the sort of the cornerstones, the legal cornerstones that were established in regard to undue influence in the
right.
tests. And now how were they dovetailed into this case?
So in this case, the brother who was challenging the power of attorney said that in his view, the proper test would be the one that you mentioned in regard to gifts during lifetime. And so in that situation, it would have been the brother who was the sole power of attorney who would have had to prove that there was no undue influence. The lower decision said that that was wrong, and that the actually they didn't consider that issue as it wasn't raised before the motion judge. But on appeal, the Court of Appeal said that the motion judge's discussion of the testamentary undue influence test was correct.
Oh.
and that it actually was the person alleging undue influence who had to prove it. And in any event, the Court of Appeal found that there was no evidence on the record of undue influence in this situation.
So the court kind of gave us some more clarity on an important element of what a test is while you're alive for undue influence and what a test is when you're not alive. One of the things that the court struggled a little bit was the role of capacity assessors in the question of undue influence. Now, undue influence, we get capacity opinions lots of times from on a retrospective basis in will challenges that an expert, some of the leading experts, Dr. Michelle Silberfeld or Dr. Ken Schulman at Sunnybrook, they'll give an opinion. There's others that will give an opinion on testamentary capacity and undue influence and whether or not you were unduly influenced at the time you made the will. Here, the court had to look at, well, what is a capacity assessor? And that's what Dr. Silberfeld and Schulman essentially are on a retrospective basis. But what does a capacity assessor during your lifetime have to do with the question of undue influence? And do they have a role? And a capacity assessor in Ontario, but it's consistent throughout Canada, is that person is trained and qualified to come in and assess someone's capacity while they're alive as to whether or not they're capable of doing the legal event that's occurring. For example, do a power of attorney for property. So in this case, the court didn't solve it, but they raised the question of the role of of a capacity assessor in a non-testamentary scenario, in a situation where a capacity assessor comes in, assesses the individual, and whether or not that person should be giving any opinion on the question of undue influence. Capacity, sure, you're qualified to do that, but can you as a capacity assessor really add any help to the court or any value to this process by opining on undue influence? And what did you think of those comments?
Well, I thought it was interesting, and it wasn't really a question of whether, in this situation, the capacity assessor's evidence on that point would be included, because the motion judge in this case held that it was inadmissible and unreliable on that point. But the mother, Rita, one of the respondents, her counsel raised the issue of whether the court should say generally that this practice of a capacity assessor considering undue influence should be said to be inappropriate, and her position was that the assessors don't have a proper understanding of the law and they don't have the authority under the Substitute Decisions Act to do that. So that was an interesting issue, I thought, that was raised.
But I don't think it was solved by the
No,
court.
it wasn't
I think it's
solved.
still an open question, and I think the role of a capacity assessor to opine on undue influence is still an open question,
Right.
and I think that's probably right, because in this case, the court really couldn't close the deal. It didn't have the evidence in front of it.
Right.
But I think it's still an open question, and I don't think that it's a yes or no. I think so. I would take the position that they probably still have a bit of a role in this process, but if they don't, they don't. We'll see what side of the case you're on if
Right.
you have to argue.
Right.
I think that sort of gives us some highlights of what is an interesting and important decision that the Court of Appeal has recently rendered. It's Vanier versus Vanier, as I say, and I don't really think we have to cover too much more. It's a big decision, and there's lots of other comments that you can consider on it, so I highly recommend you read it. Thanks a lot, Rebecca.
Thanks, Ian.